Hi, and welcome to our next installment of video lectures on school law. This installment is going to be dedicated to religion in schools. And this is a very complex issue that has its origin in the historical development of schools in our country, as we discussed last time, of the Deluder of Satan law in Massachusetts. And it continued, but it became more and more complex as schools became government institutions. And the development of our Constitution and the amendments to the Constitution created challenges. Many of these are still around today in things like the parent rights movement, and of course, the discussion about whether we should support vouchers for students to go to religious schools. So this argument is an old argument, but it's an argument that remains very significant part of education and the cultural fabric of our country with education law today. And so let's start with the First Amendment. The First Amendment reads like this: Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof. I'll stop there because those are the two clauses that focus on religion. The remainder of the First Amendment we will address in subsequent discussions about speech in the press and assembly. But the two clauses that make up the, quote, freedom of religion are actually quite different. And in many cases, these two clauses, the Establishment Clause and the Free Exercise Clause, bump into each other, because in many cases, the free exercise of religion interferes with the idea that there is an established religion by the government, particularly in the schoolhouse. And it is further complicated by different approaches that came in different states prior to the passage of the 14th Amendment. Because as we learned about, it was a common practice to read the Bible, to pray, and to have religious elements of the school curriculum from state to state. But the 14th Amendment, when it was passed in the post-Civil War era, stated that the First Amendment to the Constitution applied to state law in addition to the national government. And again, I will go back. It says Congress shall make no law. So that's the federal government. But once the 14th Amendment was passed and the country, the national state of the United States, was further fortified in the post-Civil War era, this began to basically read that Congress or state legislatures shall make no law that interferes with the establishment of religion or creates the establishment of religion and interferes with free exercise. But this notion that there should be a wall of separation from the national government and state governments to religion is a long-standing idea. Thomas Jefferson is the one who uttered the words wall of separation. One of the early cases that you are looking at is Everson v. Board of Education, which talks about public tax support to religious schools. And this is still a very complex issue, but generally speaking, the early courts struck down any type of tax support to private schools using public dollars. One of the other early Establishment Clause cases in the 1970s called Lemon v. Kurtzman created something called the Lemon Test, which really talked about this notion of what are the entangling elements of support that can be granted to private schools, parochial schools with public tax dollars. And there are a whole host of things. Curricular materials, many of those were struck down. Some of those are allowable. Staffing generally has been struck down unless it's Title funded staff that are still employed by the school district at the public level that do interventions with the parochial students. And so that's providing that support, but not with their employees. Transportation is one example where there is really a lot of support because that does not entail any kind of real established religion. It separates out those different uses. And so that's really what the Lemon test did. And so it's this idea of strict separation versus the system providing non-preference versus non-coercion, how you coerce people toward religion. And those are really the three arguments right now: strictly separating out religion from schools, presenting it in a way where there's non-preference, and having non-coercive approaches. The voucher debate is also one that is very significant today, and the Zellman versus Simmons-Harris upheld an Ohio voucher program and said it did not violate the Establishment Clause. And so the idea of giving parents public tax dollars to allow their students to go to parochial schools, religious schools, was deemed legal. And of course, this opened up this movement. We see this in Kentucky. The most recent case that is being heard through the court system has been the Commonwealth versus Cameron, which focuses on the scholarship program. Can we put scholarship tax dollars aside and grant them to parents to send their children to Catholic schools or other religious schools? It's been struck down in Kentucky for some reasons that we'll get into as we talk further about this decision in class that are very nuanced. Another concept that is important that comes up is called the child benefit theory. And this is where applying the Lemon test, things like textbooks, things like release time, things like tuition reimbursement for certain programs, those are typically been allowed as permissible because there is a child benefit and it is completely outside. Transportation would also be included in this. It's outside of any established religion, and it can still be deployed to students in private settings. The primary cases that focus on the free exercise clause, Engel versus Vitale is one of the most relevant and significant ones. 1962 outlawed school prayer. New York had a compulsory prayer that was drafted and done every day school-wide. And that was struck down in 1962 as a violation of the free exercise of religion clause. Shemp and Murray cases came later. And after the Engel-Vitale decision, there were all kinds of opportunities to try to see how you could sort of circumvent what prayer was. And so one was Bible readings. That was found unconstitutional. The Wallace v. Jaffrey, 1985, the court struck down silent meditation as unconstitutional. Again, compelling people to participate is part of the issue, and that's that whole coercion versus non-coercion issue that we talked about a moment ago. Student-initiated religious speech, religion not foreclosed from schools as long as it's not under the supervision and oversight of the school. School cannot cross the line, but also cannot endorse or encourage participation. And so you see a whole host of cases where you see this free exercise conflicting with the Establishment Clause. Stone v. Graham looked at religious symbolism, stating that it was unconstitutional to post the Ten Commandments in classrooms. Prayer at graduation and extracurricular activities, even non-sectarian prayers, legitimately convey or advance religion on the part of the state. And that's, again, that coercive issue. And of course, there's also that came through in the Santa Fe case versus Doe. And then the flag pledge required participation, the West Virginia v. Barnett case in 1943, because it was hand on the heart, under God. The flag pledge, you cannot compel. You can still recite and you can still say under God, but you cannot compel a student and punish the student, as is the case in West Virginia. In 1984, Congress passed something called the Equal Access Act. And again, if cases are unconstitutional by the Supreme Court, the only recourse is for Congress to pass a law or an amendment that sort of challenges that. And that's what the Equal Access did. And this was ways to allow religious groups to practice on the school grounds, maybe not during the school day, but this is where you have clubs like the Fellowship of Christian Athletes and other Bible clubs and things like that that occur on school grounds. It was upheld by the Supreme Court in 1990 in the Mergens case. Students have a right to organize their own groups in public schools, religious, political, philosophical. And this is where you get into a very challenging component of this, and that's the whole idea of viewpoint discrimination, because the Equal Access Act allows you to do Bible readings, but it also allows you to read the Quran or to practice Jewish religious and cultural ideas in the same way that you allow and have to uphold Christian ideas. And so you can't discriminate based on viewpoints. Equal Access Act is equal access to all religious expression. And that is also something that creates challenging circumstances, because there are students that will challenge that and want to talk about satanic issues at school. What do? According to the Equal Access Act and viewpoint discrimination, you have to be very careful about prohibiting that. The other issue is the use of public facilities, the free speech test and the public forum test. The Good News Club versus Milford in 2001 basically said that these type of activities can occur on public facilities as long as you're treating it as a public forum and you allow for these things to occur on your sites and settings. And again, that's one of the reasons that you see some schools allowing churches to worship on the school grounds on Sundays, because you're looking at the public facilities as part of that equal access. And of course, creating a limited public forum, schools cannot limit speech in the use of these facilities, but they also cannot be exclusive in use based on beliefs. So if you open the door to a religious use on Sundays, you have to consider, then do you have to use it on Friday night as a mosque? And so it's a very dicey circumstance that you as an administrator might find yourself in dealing with the use of public facilities. A couple of other cases that I think are important, that you are reading. You're reading these three cases, and the Everson case is the one that really began to establish that question of prohibiting public funding for curricular and for use of religious purposes. And the Lemon v. Kurtzman applies the Lemon test. And so you're going to go through and evaluate that. And then the West Virginia State Board v. Barnett, the flag pledge is and has been a controversial, and I like, this is a good way to close. I like this quote from the West Virginia case. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. History isn't a pledge, it's an argument. Very wise words. And it's also timely, because many of these same debates, I think, have revved up in our schools, not only around religious issues, but also cultural issues that we're going to talk about when we get into free speech And we're going to talk about when we get into banning books and some of those kind of issues that are issues that administrators in your buildings are grappling with right now. And so it's important for us to make sense of these and understand how to proceed effectively, prudently, legally, and appropriately. I look forward to those discussions.